Hello and welcome to UGCE Pathshala. I am Dr. Swikar Lama, Assistant Professor in Criminology and Police Studies at Sardar Patel University of Police Security and Criminal Justice, Jodhpur. I am going to present the module on relevant legislations related to organized crime. The learning outcomes of this module are to make the learners understand the concept of organized crime and to make the learners understand various legislations related to organized crime. The global nature of organized crime, terrorism, corruption and economic crime requires multilateral approach and solidarity within the international community. These forms of serious crime, in particularly terrorism, continue to spread throughout the world in more sophisticated and dangerous forms. A nation considers terrorist attacks and their barbaric methods as a threat against the values of freedom, democracy, justice, and the rule of law and human rights, particularly the right to life, and that is why we support all actions regarding the fight against terrorism, initiated at various international fora. Crime as a phenomena that does not distinguish national frontiers poses great challenges which require joint efforts of all states and relevant institutions. The unique position of the United Nations, being an international organization of a global character, offers a great opportunity to tackle the problems of organized crime, terrorism, corruption and various forms of economic crime at a transnational level. The condition of a successful strategy of the fight against terrorism and organized crime is to exceed the framework of the national frontiers towards not only international but transnational cooperation, since terrorism and organized crime has a transnational nature. Fight against terrorism and organized crime requires in particularly the perfect and faultless domestic legislation and an effective system of international instruments which should ensure the prevention and elimination of sources of crime, functioning of an effective law enforcement structure and mechanisms of sanctions and universal cross-border cooperation of all law enforcement authorities, police prosecuting authorities and courts of all democratic states. At the same time, it is important to take into account the principle that the fight against organized crime, including terrorism, must be compatible with fundamental freedoms and human rights that form the basic values of our civilization. We must not forget that it is these values against which terrorist attacks are aimed at. Now I will discuss about organized crime in India. After independence, organized crime in India expanded into a wider range of activities and extended over large geographical areas. The single event which brought about the greatest change in organized crime was the idea of prohibition, forbidding by law the state and distribution of alcoholic beverages. Organized crime was able to provide illegal liquor demanded by a large number of people. So many groups or gangs came to be engaged in manufacturing illicit liquor that they started fighting with one another. Inter-rivalries amongst them led to widespread use of violence. Quite a few of these gangs, the strongest, finally dominated the scene. In the 1970s, many of these gangs extended their activity to drug trafficking. Political wrangling for a separate states created a large demand for arms and weapons. Some gangs or syndicates started supplying illicit arms to insurgents, terrorists, Naxalites and agitators. Some gangs further extended their activities to supplying girls to rich people in Islamic countries. Thus, the organized groups, because of the large sums of money they had amassed and the elaborate organization they possessed, not only widely expanded their illegal activities but also started acting as kings of the underworld. The modern era of organized crime is represented by the crime syndicate. Organized crime has been expanded to the point where policemen, political leaders, law officers have also come to be associated with the gangs and syndicates. Many gang leaders contested elections to assemblies, parliament, municipal corporations and gram panchayats, thereby securing political status which enables them to widen their social contacts and use the influence of powerful people for escaping arrest after committing crimes. These gangs and syndicates today not only enjoy large financial gains but also enjoy immunity from interference and possess monopolistic control in large geographical areas. Major criminal enterprises are providing illicit profits in India are numbers betting, drug trafficking, estate racketeering, automobile thefts, and supplying illicit weapons to terrorists and insurgents. On a lower level, the two main criminal enterprises are kidnapping for extortion and supplying girls for prostitution. Now, what is the legal position in India on organized crime? Organized crime has always existed in India in some form or the other. It has, however, assumed its virulent form in modern times due to several socio-economic and political factors and advances in science and technology. Even though rural India is not immune from it, it is essentially an urban phenomenon. In India, there is no comprehensive law to control organized crime in all its dimensions and manifestations. There is, however, substantive law regarding criminal conspiracy. There are also penal provisions in various statutes against specific violations of those statutes. Criminal conspiracy. Section 120A of the Indian Penal Code defines criminal conspiracy as when two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means. Such an agreement is designated as criminal conspiracy, provided that no agreement except an agreement to commit an offence shall amount to criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. It is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. Section 120B of the Indian Penal Code provides for punishment for criminal conspiracy. The punishment for the conspirators is the same for the principal offender. It may, however, be emphasized that the criminal conspiracy by itself is a substantive offence. The conspiracy need and fructify, and the mere proof of the existence of the criminal conspiracy is adequate to have the criminal punished for such criminal conspiracy. Dacoity and related offences is one of the oldest forms of crimes in India and is committed purely for the purpose of looting or extortion. Section 391 of the Penal Code defines dacoity as when 5 or more persons conjointly commit or attempt to commit a robbery, or where the whole number of persons conjointly committing or attempted to commit a robbery and persons present and aiding such commission or attempt amount to 5 or more, every person so committing, attempting or aiding is said to commit dacoity. In other words, if 5 or more persons commit the offence of robbery, they commit dacoity. Dacoity is punishable with imprisonment for life or rigorous imprisonment up to 10 years and 5 months. Section 395 of Indian Penal Code. The code also criminalizes preparation to commit dacoity, Section 399, and assembly for the purpose of committing dacoity, which is Section 402. Importantly, Section 400 of the code criminalizes the act of belonging to a gang of persons associated for the purpose of habitually committing dacoities. The punishment is quite severe and may even extend to life imprisonment. Similarly, Section 401 criminalizes the act of belonging to a gang of thieves. It would thus appear that adequate legislative tools are available to the law enforcement agencies to deal with gangs of dacoits and thieves. But the proof of existence of a gang in court requires painstaking investigation. In view of increasing incidents of kidnapping for ransom, the Parliament inserted Section 364A in the Indian Penal Code to provide for stringent punishment for such offences, further strengthened in 1995. The amended Section 364A reads like, whoever kidnaps or abducts any person or keeps a person in detention after such kidnapping or abduction and threatens to cause death or hurt to such person or by his conduct gives rise to a reasonable apprehension that such person may be put to death or hurt or causes hurt or death to such person in order to compel the government of any foreign state or international intergovernmental organizations to do or abstain from doing any act or to pay shall be punishable with death or imprisonment for life and shall also be liable to fine. Now, the law on gangsters. There is no central legislation to suppress gang activity having countrywide applicability. The state of Uttar Pradesh, most populous and politically most powerful, enacted Uttar Pradesh Gangsters and Anti-Social Activities Prevention Act 1986, which is applicable in that state only. The gang has been defined as a group of persons who singly or collectively indulge in anti-national activities by violence or threat of violence for gaining undue political, economic or physical advantages, and includes offences against the body, bootlegging, forcible possession of immovable property, creating communal disturbances, obstructing public servants in the discharge of the duties, kidnapping for ransom, diverting an aircraft or public transport vehicle from the scheduled path. A gangster is punishable with minimum imprisonment of 2 years, extendable up to 10 years. Section 3 of the Act. The rules of evidence have been modified and certain statutory presumptions can be raised against the gangsters by the trial court. Provisions have also been made for the protection of witnesses. The trial may be held in camera on the request of public prosecutor. The name and address of a witness can be omitted in the court records if the court so desires. The property of the gangster can be attached by the district magistrate if satisfied that it was acquired through criminal activity. This act has a wide canvas and purports to cover large areas of organized criminal activity. It is, however, different from laws enacted in foreign countries in that, apart from criminalizing money-making activities of the criminal gangs, it also criminalizes infringement of election laws causing obstruction or disturbance in the pursuit of lawful trade, business or profession, and incitement to violence and disturbance of communal harmony. It appears to be more comprehensive than the Racketeer Influenced and Corrupt Organization Act (RICO). There is no form data available to assess its effectiveness. It appears that due to inadequate investigations and inordinately delayed trials by the courts, this legislation has not been able to make any dent on the criminal landscape of the state. Now the Maharashtra Control of Organized Crime Act MCOCA 1999. Maharashtra Control of Organized Crime Act MCOCA 99 is a law enacted by Maharashtra in 1999 to combat organized crime and terrorism. The penal and procedural laws and the adjudicatory system are found to be rather inadequate to curb or control the menace of organized crime. Government has therefore decided to enact a special law with stringent and deterrent provisions, including in certain circumstances power to intercept via electronic or oral communication to control the menace of organized crime. Unlike normal law, the confessions before senior police officers are admissible not only against the accused giving the confession but also against the other accused in the same case. There is no provision for granting anticipatory bail for 6 months to the accused. MCOCA puts a bar on soft liberal bail provisions. Under MCOCA, not bail but jail is the controlling principle. Police can file charge sheet within 180 days instead of 90 days time limit in normal cases. There are measures in MCOCA which ensures protection of witnesses, like keeping the identity and address of the witness secret, and the witness need not be produced in the court. In addition to these acts, there are other laws in India. There are several other central statutes which deal with specific facets of organized crime. Some of them are the Customs Act 1962, Narcotics, Drugs and Psychotropic Substances 1984, the Immoral Traffic Prevention Act 1956 and the Public Gambling Act. Other laws relating to organized economic crimes are Income Tax Act, Customs Act 1962, Coffee Posa 1974, Central Excise and Salt Act 1944, Antiquity and Art Treasures Act 1972, Foreign Exchange Regulations 1973, Foreign Contribution Regulation Act 1976, Banking Regulation Act 1949, Prevention of Corruption Act 1988, Import and Export Control Act 1947, Passport Act 1920, Companies Act 1956, IT Act 2002 and Prevention of Money Laundering Act 2002. Now let's talk about preventive action. The National Security Act 1980 provides for preventive detention by the central government or the state government or by the officers designated by these governments. The detention order is issued for 1 year with a view to preventing a person from acting in any manner prejudicial to the defense of India or to the friendly relations with foreign powers. The detention has to be approved by an advisory board headed by a serving High Court judge. The expression security of India is open to liberal interpretation, and this act has been used though sparingly against anti-national elements and hardcore gangsters. Detention is an executive action and the case does not go to the court for trial. Now let us briefly talk about the international framework to combat organized crime. Cooperation in criminal matters is a very sensitive issue. Its effectiveness often depends on the confidential exchange of information and a common interest in the success of a particular operation. During the Cold War, such mutual confidence was rather limited in the community of states. Organized crime was moreover perceived as being primarily a domestic problem. Yet the lack of common interests and mutual confidence and the slowly developing awareness of the transnational dimensions of organized crime explain only in part why states have been reluctant to establish a legally binding multilateral framework designed to encourage and promote international cooperation for the suppression of organized crime. As transnational offending truly a catch-all term understood to mean deviant behavior at a level of criminality that by the very nature necessarily involves either transcending state borders, violating the laws of several states, or evading a state's jurisdiction by not being attributable to it a certain state territory, many forms of organized crime have tended to be subject to so-called suppression treaties, that is multilateral agreements between state parties in order to fight deviance effectively from an international perspective. The United Nations Convention Against Transnational Organized Crime is a very important convention. In view of these antecedents, the United Nations Convention Against Transnational Organized Crime (UNCTOC), adopted in Palermo, Italy on 15 December 2000 marks a major breakthrough. As a brief outline of its content and significance shows, the declared purpose of the convention is to promote cooperation to prevent and combat transnational organized crime. Since the effectiveness of such cooperation depends on the applicability of common legal standards, the convention obliges states parties to criminalize participation in an organized criminal group, corruption, the laundering of the proceeds of crime, money laundering, and the obstruction of justice. It thus focuses on the enabling of secondary activities that are characteristic of organized crime. The primary activities have been separated from the core instrument and are dealt with by the three protocols thereto. This approach facilitated finding a consensus and increases the Palermo Convention's chance of gaining universal acceptance. Indeed, it already has 147 state parties. Moreover, the decision to deal with the primary activities in autonomous international treaties allows for the adoption of further protocols dedicated to specific aspects that are not covered by the existing instruments. It also facilitates its revision and amendment. The Convention Against Transnational Organized Crime does not lay down a legal definition of transnational organized crime. As we have seen, a consensus to that effect would have been impossible to reach, and the desirability of such a definition may be questionable in light of the dynamics explained of the phenomena. However, the convention does specify the use of some basic terms in order to give states some necessary guidance for its implementation in national law. Article 2 contains meaningful explanations with regard to the duty to criminalize participation and organized criminal group. Article 5 of the convention. It stipulates that for the purposes of the convention, organized criminal group shall mean a structured group of 3 or more persons existing for a period of time and acting in concert with the aim of committing one or more serious crimes or offences established in accordance with this convention, in order to obtain directly or indirectly a financial or other material benefit. Serious crime shall mean conduct constituting an offence punishable by a maximum deprivation of liberty or at least 4 years or a more serious penalty. Structured group shall mean a group that is not randomly formed for the immediate commission of an offence and that does not need to have formally defined roles for its members. continuity of its membership, or a developed structure. These definitions are subject to criticism for being over-inclusive and vague. While the point is relatively easy to make, it must not be overlooked that the consensus reached is nonetheless a remarkable achievement. Since it is the result of difficult multilateral negotiations, it at least represents a quasi-universal common denominator. The definition recognizes that criminal associations do not always have a hierarchical structure comparable to real enterprises, but often function as networks consisting of a few loosely connected members. Nonetheless, there has to exist a structured group that is not randomly formed for the immediate commission of an offense. This means that more spontaneous forms of collective criminality are excluded from it. This is an important limitation that may help to draw a line between organized crime and gang criminality. Furthermore, the subjective element, in order to obtain directly or indirectly a financial or other material benefit, confirms the dominant view that organized crime is not driven by political motives but is primarily out to make a profit. Groups such as terrorists and insurgents are therefore not covered by the scope of application of the Convention Against Transnational Organized Crime. This protects the convention from being overly politicized. Whether such an important consensus could have been achieved after the 11 September 2000 terrorist attack on the United States and the US proclaimed merger of terrorism and organized crime is doubtful. Now, to conclude, organized crime is first of all a domestic problem, and when unchecked it assumes a transnational character. Organized crime succeeds so long as nations permit it to succeed. The first and foremost step in our control efforts should be to keep incident or ordinary crime within reasonable bounds by keeping criminal elements under relentless law enforcement pressure. If we succeed in this effort, we would have obviated or at least diminished the possibility of unattached criminal networks and the phenomena of organized crime. Organized crime, depending upon its intensity, spread and dimensions, must be combated by a deft mix of strengthening of criminal laws and criminal justice system, institutionalizing a national and state level coordinating mechanism, and involving the mass media in control efforts. Law enforcement, however efficient, cannot succeed by itself without strong political commitment. This presupposes exclusion of criminal elements and their political sympathizers from elected public offices. As organized crime is for the acquisition of money and power, it is imperative that the flow of money to organized criminal groups is dried up through stringent legislative and enforcement action. A democracy has inherent infirmities which manifest themselves in the functioning of criminal justice agencies. Despite best efforts, domestic crime is likely to spill into the international era and often does. Hence, the need for international cooperation in suppressing it in the form of expeditious extradition of fugitive criminals, deportation of undesirable aliens, mutual legal assistance in investigations and prosecutions, and speedy execution of red courier notices issued by Interpol. Further, the international community must put their heads together to harmonize extradition and deportation laws and to narrow the scope of political offences in extradition laws and the Interpol Charter. National strategies are inherently inadequate for responding to challenges that cross multiple borders and involve multiple jurisdictions and a multiplicity of laws. The rapid growth in transnational organized crime and the complexity of the investigations requires a global response. At present, the measures adopted to counter organized crime are not only predominantly national, but these measures differ from one country to another. It is absolutely imperative to increase cooperation between the world's law enforcement agencies and to continue to develop the tools which will help them effectively counter transnational organized crime. In India, the Extradition Act 1962 deals with extradition of fugitive criminals. Extradition can be made if the offence is an extraditable offence, that is, an offence provided for in the extradition treaty with a state which is a treaty state, and for other countries an offence which is specified under the second schedule of the Act. Under the schedule, there are 18 types of offences. India has extradition treaties with Nepal, Belgium, Canada, Netherlands, the United Kingdom, the United States of America, Switzerland, Bhutan and Hong Kong, and extradition arrangements with Sweden, Tanzania, Australia, Singapore, Sri Lanka, Papua New Guinea, Fiji and Thailand. Extradition treaties with Russia, Germany, UAE, Bulgaria, Thailand, France, Ukraine, Romania, Oman, Spain, Kazakhstan, Greece, Egypt, Malaysia and Mauritius are under finalization. Section 166 of the Criminal Procedure Code deals with reciprocal arrangements regarding processes. A court in India can send summons or warrants in duplicate to a court in a foreign country for service or execution, and the said foreign court will cause the service or execution. Section 166A of the Criminal Procedure Code provides for letters of request to the competent authority for investigation in a foreign country. A criminal court in India may issue a letter of request to a court or a competent authority to examine orally any person supposed to be acquainted with the facts and circumstances of the case, to record the statement made in the course of such examination, and also to require such person or any other person to produce any document or thing. Similarly, Section 166B provides for letters of request from a country or place outside India to a court or an authority for investigation in India. Under this provision, the central government may forward the letter of request received from foreign country to a magistrate, who may summon such person and record his statement. The central government can also send the letter to a police officer who will investigate the offence. The fight against transnational crime is a formidable task, but heightened public consciousness, increasing governmental concern and mutually dependent interests of the international community do give us a ray of hope. Thank you.